This is The Law Show on CL 650. Now back to the show.
Welcome back to The Law Show this Sunday morning here on CIL 650. I'm Sterling Fox, joined by David Halkett from Macquarie Hunter. David is a partner in Macquarie Hunter, and he is the head of the family law section within Macquarie Hunter, a large Surrey-based firm. You're in the big building, impossible to miss, right there at Surrey Central Plaza, where Simon Fraser is.
Exactly.
The same building, right?
Yeah, the same building.
Okay, cool. Want to talk a little bit about the Family Law Act. We've mentioned it a few times. It was passed. It was the legislation came through in the early part of 2010, 2011, but it wasn't actually proclaimed into law until about 2 years ago now.
It
right?
came into effect March 18th of 2013.
Okay, so in addition to basically updating everything, what was the big push behind the creation of the Family Law Act in BC?
Well, I was involved with working groups and giving our Canadian Bar Association views on the proposed legislation, and from what I can gather, it was families are different now than they were in 1979 when the Family Relations Act came in.
Oh, that was the last. That's the previous piece.
Exactly.
Okay.
So now we have same-sex couples.
Sure.
That they're married. They hadn't been married before. We have a lot of common law couples who acquire assets and don't get married.
Mm-hmm.
So they thought we got to deal with the property division to get with the times. They also knew that terms like custody and access are inflammatory terms, and they cause a lot of disputes. So they took those terms out of the provincial legislation, and we deal with what they call guardianship and parenting time or contact.
And all the disputes have gone away, haven't they?
Of course.
Because they changed those nasty words.
Exactly. We just argue over different things.
Nah, come on.
But
that was a politically correct kind of new millennium twist to the plot, right?
Exactly. And the funny thing, though, Sterling, is the Divorce Act is still in effect,
right?
Which uses custody
and access. Right, of course. So, but the provincial law talks about guardianship now.
Exactly, and parenting time or contact and parental responsibilities.
So have you handled, by the way, it's interesting that because we are talking a changing reality in family law, and in addition to child guardianship or custody, I may fall back into my custody, and please don't hit me.
I still do, too.
Okay, good. I feel better already. But when we're talking about those matters, in the context of new law, where a lot of society has changed. For example, have you handled yet a same-sex marriage divorcing?
I haven't dealt with a divorce in a same-sex relationship,
right?
But I have dealt with same-sex breakdown of relationships that were not married.
Okay, common law.
And it's amazing the same issues of law.
Of course,
there's the same emotional issues that are there. There's still the risk of family violence between both parties. One is potentially more dominant than the other, and more economically powerful, and it always shows that no matter whether you're same-sex, heterosexual, homosexual, we have the same issues.
Exactly.
We're the same people.
Right. I'm just curious about that because, of course, society is changing. And,
exactly.
And I was just wondering the sort of case files that have crossed your desk in the past little while.
They've been a wide range.
I'm sure.
I've had people who I had one case once where the person had 2 children with 2 different men in the same year, the same calendar year.
Oh, my.
Had one in January, one in December. Just one of those kind of interesting aspects. I've had seniors getting divorced because that's a lot of people in their 50s are getting remarried. They've been divorced the first time, but then if they get divorced the second time.
Oh, the 50-year-old marries the 25-year-old, and that doesn't go so well after 3 or 4 years.
Sometimes, yeah. Although a lot of them, I read that people in their 50s are the second largest age group getting married. It's her second marriage.
Interesting stuff.
Yeah.
That age group, eh?
So when I went to my 20-year high school reunion, I thought, gee, I should take a pack of my cards. They're like 38, 40 years old. Time to get them divorced.
That's very funny. You mentioned earlier something, and I'm assuming this is really a building block, a foundation of the Family Law Act. You talked about the critical emphasis being placed on the protection of the interests of the child.
That's correct.
That has to dominate everything through all proceedings at all times.
All decisions made by the court or the parties with respect to children The only issue we look at is their best interest. What's best for the children?
Right.
Whether it be half-time with their parents or be, more with one than the other. What contact, what protection we needs to be if there's been a risk of abuse or if there has been abuse, if there's been family violence. It all factors into what's best for the children.
Well, now here's I know you've seen this. I can't say anything to this guy. He's been a family lawyer for 20 years, so I can run pretty much anything by him, and I know he's going to, oh, yeah, I've seen those.
Yep.
So let me try this one on for size. It's in the best interest of the child. Child's 12, just starting high school. Family's got a fair bit of dough. Money's not an object. The divorcing dad wants the child to go to private school in Switzerland. Mom wants the child to go to local school in Langley. The best interest of the child, the father's lawyer will argue, is the opportunity to go abroad, enhance not only their physical education, but their life experience, and so on and so on. And of course, lawyer's gonna say, well, no, he's 12. He needs to be home close to mom. So here you're the mediator, because I would assume these things obviously go through a series of processes before they ever get to court.
They should, yep.
So how does that circle get squared, David?
Well, that would be I think that would be one that would have to go before a judge to make the decision, because the two parties are so diametrically opposed in position. I can't see how they'd ever mediate it. I would suspect they'd look at the age of the child and what his views. When you're 12 under the FLA, you can be asked for your views.
They can ask you now.
Yes.
Oh, okay.
And so there may be a report prepared, the views of the child. What does the child want? It's not a determinative choice, but it's a voice for the child.
Oh, okay. So the child actually, his or her feelings or thoughts are at least considered.
Exactly.
Okay.
You might also look at what were the plans the parents had for this child. Was it always a plan that they would send the child to a private school when they were together?
Right. Or is this a consequence of, now that we've split up, I'm going to get Junior out of your life as much as I can?
Is the dad doing it simply so he doesn't have to pay child maintenance? And then also, how much is the school going to cost? Because the parties would have to split that proportionately as an extraordinary expense.
Oh, even though Dad would be prepared to foot the bill 100%?
He probably would. That would be his final position.
Right.
He'd probably say, I want it split. And he may agree at the end to pay it all. It would seem to me, at a child 12 to be sent away to a boarding school, so to speak, in Europe, probably the court would err on the side of leaving it at home.
I think so too. At what age? Now that when do they start asking kids? So what do you think about this?
As young as 8.
Oh, is that right?
Yeah. Now, obviously,
that always hasn't been the case, though, has it?
No, it's only recently that they've been asking more. There's programs that's called Here Are the Child Reports and Views of the Child Reports. The younger the child, so the closer it is to 8, the less likely they're going to have a choice.
Right.
When they start getting up to 14, no judge is going to force them to see either parent if they don't want to.
Oh, really?
Usually 14 is kind of a cutoff. And it's interesting culturally, because being that we're a multicultural city, people who are born in North America say, well, 14, they pretty well decide. I've had cases with people from South America who say, well, what do you mean the child decides? He's a child. He's 14.
That's right.
And they can't understand how our system goes. So it's our job to explain how our legal system works, even despite the cultural differences.
Well, you're on the law show, my friend. How does it work? How does a 14-year-old... Now, I can appreciate some pretty darn acrimonious divorces. Mom and dad just can't stand to be in the same province with each other, let alone the same city. And here's a kid just bouncing around like a ping pong ball between two parties who hate each other. And this could be a pawn in many of their little mind game wars.
Exactly.
And he's sick to death of it. I want a pox on both your houses. So what does a 14-year-old do when he or she just wants out of this mess?
Well, in some of my cases, the child has just said, I'm not living with either of them. He's gone to live with an uncle.
Oh, okay.
Friends
and now will the courts make accommodations for those wishes?
It's called choosing with their feet, so to speak. So the court will say, look, the child has decided to go and live with the uncle.
Right.
Right now, I can't order him to go back. Even though the court has the ultimate authority to order someone, they're not going to throw a 14 or 15-year-old child into a paddy wagon, for lack of a better term.
And send him back to kicking and screaming to a parent he can't stand.
Because he may just run away.
Right.
And so in that case, the court would look at what's best for this child, which would likely be he's staying somewhere else. So let's get family counseling together, see if we can figure out what's wrong. And he'd probably yell at the parents with without yelling and raising his voice strongly and
Right,
saying,
right.
you two have to work out your issues because this is affecting your child.
Exactly. David, let's take a quick break here. When we're talking family law in British Columbia and the new Family Law Act, as David has been instructing us over the past while, one thing that comes pretty clear is the number of new players on the field and what their jobs are to try and keep, well, 95% of the cases from going to court. It takes people, and it takes some new approaches and techniques. And we'll talk about that when we continue. Our guest is David Halkett from McQuarrieHunterLLP in Surrey, and this is The Law Show on Sea Isle.
There's more of the show still ahead. This is The Law Show on Sea Isle 650.